continue this all day, I also will add you to the case if you want to continue this. This needs to be dismissed today.
Wait, he says the court has no power over him, but still wants it to rule in his favor. This case is pure chaos, contradictions, and a judge who's not buying any of it. Hit subscribe right now because this gets wild fast.
Good morning. The 36th District Court in the state of Michigan is now in session with the Honorable Judge Donald Coleman presiding. While court is in session, there will be no talking, sleeping, chewing gum, or reading any material. Thank you.
Thank you. This is case number 23-152244. This is Javar Grayson versus Brian Ambrose. The matter is before the court where there is an application for entry of a default judgment. The court has set the matter on in regard to that motion. Your appearance for any attorney who's appearing on either side, your appearance in the first instance, please.
Thank you, Your Honor. Christopher Michaels, P8315, on behalf of Police Officer Brian Ambrose. And briefly, there was also the defendant's motion to dismiss in lieu of answer was filed. I don't know if today is the date and time for that as well.
I do have that matter that was filed with the court June the 30th and submitted to the court. So that is an issue that's before the court as well. All right, and do I have Javar Grayson on this Zoom? Say something if you're here at this time.
Yes, Your Honor. Javar Grayson representing myself.
All right, thank you, Mr. Grayson. Good morning to you as
Good morning.
well. So, all right, I see that there is the, let me address the issue of the application for entry of default judgment in this matter. On what basis are you saying, Mr. Grayson, that you should be entitled to entry of default judgment in this matter, sir?
Well, Your Honor, we sent documents into you stating that I'm a national, a Morris American, and this highwayman has no jurisdiction over me. And we sent that information to you, and also sent, I believe I have a court, People versus Battle as a reference in the case.
I think that you're addressing something that don't have anything to do with my question. You
Okay.
submitted to the court a default request. Now, on one hand, you're telling me that the court doesn't have jurisdiction. You telling me that the court doesn't have jurisdiction, and you're not submitting to the jurisdiction of the court. Then why are you filing something in this court if you believe the court doesn't have jurisdiction?
I'm asking in which context would this court try to enforce jurisdiction on me?
I'm sorry, the jurisdiction that doesn't have jurisdiction, the 36th District Court, a traffic court, that's not pertaining to you. What I decided to do was send you basically every information to communicate what I've been doing basically in 36th District Court, as well as this procedure.
I'm not a traffic court judge. I'm a civil judge. But I don't know where you talking about.
Yes, sir. And I understand that.
All right, Mr. Michaels, address yourself, if you will, to both issues. One is the motion for entry of default, and then secondly, which I believe these issues might collide, the motion to dismiss in lieu of filing an answer. So go right ahead, sir.
Thank you, Your Honor. I did receive a copy of the request for default this week, so I had no opportunity to respond. Obviously, the city the city law department who's representing this police officer filed its motion back in June, dismissed in lieu of an answer. So I don't believe there's any grounds whatsoever for a default judgment. The brief speaks pretty clearly on its face for why dismissal is appropriate. There is no viable claim stated in plaintiff's original complaint, and since the defendant is was at the time and still is a police officer, he would be entitled to governmental immunity. It appears that it's some sort of dispute regarding traffic tickets or citations that were given for various matters that are currently pending in front of Judge Perkins right now. So it also appears to be some sort of collateral attack against those proceedings, which is under Michigan rules not permitted. So we would ask this court dismiss this case under any of those grounds.
Well, certainly, let me begin with the default request. I don't see where the defendant is in default in this matter. He's responded to the complaint. Default is when a party fails to act in the judicial proceeding, in a court proceeding, fail to act when they should have acted, and that therefore the court would be required to enter their default because of their failure. Things like failure to answer the complaint or failure to file a responsive pleading. The responsive pleading that was filed in this matter was filed in June. The case was filed, looks like June the 13th, 2023. The motion was filed June the 30th. So that's certainly within the time required by law to do a responsive pleading. So I don't see any basis for default. Default is what, like if the defendant did not answer or didn't file a response, then the plaintiff could move for entry of default. I don't see a basis for entry of default in this matter. Now, so the motion and application for entry of default is denied. There's nothing about this case that shows that the plaintiff is in default, or for that matter, that the defendant is in default on anything. Neither party is in default. The case is right where it's supposed to be, and that is that there's been a complaint filed, and then there's been a responsive pleading. That responsive pleading is a motion to dismiss in lieu of filing an answer. If the plaintiff didn't file straight, if the defendant didn't file a motion, he would have had to file an answer to the complaint. So when there's a complaint, you got to answer within a certain period of time by either filing a written answer or by filing a motion. Sometimes there's a motion for a more definite statement. Sometimes there's a motion to dismiss because the complaint is deficient or it has some legal flaw involved.
Every case in this series has shown us what happens when someone tries to use sovereign citizen arguments to escape a court's authority. But this case presents something that none of the others have. The single most glaring logical contradiction in the entire sovereign citizen belief system, playing out in real time in front of a judge who catches it within the first 2 minutes. Javver Grayson walked into a Michigan civil courtroom to ask the court to rule in his favor, and in the same breath, he told the court it had no jurisdiction over him whatsoever. The case itself had an unusual structure. Grayson had filed a civil lawsuit against a police officer named Brian Ambrose, apparently stemming from traffic citations that were simultaneously being contested in a separate traffic court. He had then filed an application for a default judgment, arguing that the defendant had failed to respond in time. On top of that, he had sent the court documents declaring himself a Moorish American national and stating that the court, referred to as a highwayman, had no jurisdiction over him. The judge, Donald Coleman, noticed the contradiction immediately and asked the question directly. If you believe this court has no jurisdiction over you, why are you filing documents in this court asking it to rule in your favor? It is a simple question. It is a devastating question. And Grayson's response, that he was asking in which context the court would try to enforce jurisdiction on him, did not come close to answering it. He then tried to clarify that the court with no jurisdiction was the traffic court, not this civil court, and that he had sent all his documents here to communicate what he had been doing over there. The judge, a civil judge, made clear that he had nothing to do with the traffic court proceedings. From there, the defense attorney walked through why the default application had no legal basis. The defendant, the police officer, had responded to the complaint by filing a motion to dismiss, well within the time allowed by law. Default judgment only applies when a party fails to respond entirely. That had not happened here. The judge agreed, denied the default application, and explained patiently that a complaint requires either a written answer or a responsive motion, and that a motion to dismiss is a perfectly valid response. Neither party was in default. The case was exactly where it was supposed to be. What makes this case so instructive is not just the contradiction. It is what the contradiction reveals about how sovereign citizen thinking actually works in practice. The theory holds that government courts have no legitimate authority, but the moment someone using that theory feels wronged, the first instinct is to run to that same court and ask it to help. They want the power of the institution without accepting its authority. They want a favorable ruling from a system they have declared illegitimate, and courts, being what they are, simply cannot function that way. You cannot simultaneously reject a court's jurisdiction and demand its judgment. The two positions cancel each other out completely. This case is perhaps the clearest window into the fundamental internal contradiction of the sovereign citizen movement. It does not just fail in courtrooms because judges reject it. It fails because it contradicts itself. And no amount of documents, declarations, or legal-sounding terminology can paper over a logic that collapses the moment it is tested against reality.